Hello, everyone. Hello, everyone. This is Anna Hill with Officially-Unofficial. Thank you so much for being here with me, my guest, Beth Lockhart, family photographer, family lawyer with us. Thank you for being here, Beth.
Thank you for having me.
Yes. So before we get started, here is the attorney's advertising. And we are back. Okay, so we're gonna go over some of the questions that for because it has been crazy, has been insane for everybody. The situation is changing, especially when it comes to families and child custody and all these things. So we're gonna go over some of the questions that Beth has gotten from her customers and some of the questions that I've received from you guys after the post. So Beth, let's go over some of the questions that you have received from your customers regarding COVID and visitation.
Aren't they going to pop up?
Oh no, your question. You know what? We can come up with the ones for my from the questions that some of the customers have asked. Here we go. Here we go. Here we
Oh,
go. Okay. So here we go. Okay, so we're gonna go to this one, all right? So this is a question from one of my customers. I mean, from one of the viewers. My ex has refused to return my child to me, and I have full custody. What can I do to once the shelter in place order has been lifted?
so that's a good question. As of right now, our court system is not allowing new filings absent emergencies or what has been declared essential by the courts. So right now, there's not a whole lot you can do. Once the court reopens for new filings in non-essential matters, then you'll be able to bring a petition before the court for violation of your order. Um, the reality is that the judges have seemed to can I start over?
Well, yes, you're live. You can start all over again. You
Okay.
are, yeah, you're. Go ahead.
So the reality of the situation is once you can file, we do have some guidance about how the judges should be handling matters once we return to court. There's an article, a very good article by Justice Sunshine, and he's a downstate judge who writes very articulate decisions. He wrote an article on March 27th indicating that when we get through this, because it's hard enough during this situation to know what to do, and it's worse when you can't get along.
Right.
So he has indicated in his article that when we come back and we start the filings in the court system, that the judges should take the behaviors that occurred very seriously because it goes directly to the issues of custodial interference or inability to encourage and foster a relationship between the child and the other parent, which are two of the biggest factors that impact custody matters.
Yeah, and it is actually it's pretty sad when it comes to things like that because when it comes to the children and it comes I know you're pretty big on the parent relationship and as any lawyer should be, but when the parents are not agreeing on the children in terms of visitations or even just regular co-parenting and the child is in between, it is pretty tough on the kid. It is really tough. So that's awesome that the judge will take all of that into consideration. You know. So all right. So now the next question that we have is, let me get there. Okay. Oh, we're just talking about that. Okay. So here's the next question. My ex and I have a horrible relationship and do not communicate well at all. What points can I focus on to make sure we're on the same page with protecting our child from coronavirus exposure?
So most exes do have a horrible relationship. That's why they're your ex.
Mm.
There's a couple of different options out there. With the technology that we have today, there's a couple of options on how you could communicate. There's apps that are called co-parenting apps. Some of them are free or inexpensive,
Mm-hmm.
and you can send messages back and forth through the app. Um, if it's to the point that the two of you can't speak to each other without having an argument, maybe use email. Pick a designated email address or create a dedicated email address where the two of you communicate with each other solely related to the child, and address it so that it's not in an attacking manner, but more along the lines of looking for input.
Okay.
For example, oh, I saw on the news that it could stay on a box for 24 hours. The germs could stay on the box for 24 hours. So, what do you think I should do if I get mail at the house? Like, what do you think I should bring it in? What would you do?
Mm-hmm.
And then it's going to kind of give you the idea of what they're doing in their home to follow the guidelines for COVID-19.
Okay, I see. I see. Okay. Okay. And that, I mean, yeah, that way is calm and a non-threatening way.
Right, because if you already have a bad relationship, they're going to automatically assume that you're attacking them or that you're judging them or that you believe that you're smarter about this than they are. And that's not going to start off well.
Okay, all right. So I have a comment who just came in, and it says that there's an app called Two Houses, which is pretty awesome, and it tracks all conversation, money, etc. Is that one you're familiar with?
The one that I'm familiar with is called, let me just open the screen,
Mm-hmm.
AppClose. It's AppClose. It has pretty good ratings, and one of our companies that we do CLEs through typically recommends this app, and they'll hand out literature at the CLEs, and their CLEs specifically targeted to issues of divorce and family law. So
Okay.
that app I'm not in particularly familiar with, but with respect to app close, it's probably similar because they can track money, expenses, communications, but the big part is the communication, and that's
Mm-hmm.
what I'm most interested in. And most of the apps, probably in fact that app too, the attorneys involved in the case can track the communications between the parties too if it's an active case. They can authorize it
Okay.
through the app.
Okay. Wow. Things have come a long way. Because like before before it was just email, like oh email or
Yeah.
phone conversations, but then people will start like gathering all that information and having it all over the place. So these apps just keep everything organized.
Yes. Yes, it's
That's
all streamlined into one place. And right now, really, if you have an attorney, the best job the attorney can do for you right now is guide you on the communication component
mm-hmm.
because there's not a whole lot we can do right now, but
Right.
we can help you find an effective way to communicate.
Mm-hmm. I mean, communication is key. So let's go to the other question. Let me see. The other question that they had was okay. Okay. If we have two schedules, do we follow the school schedule or do we follow the summer schedule? So I'm assuming you're probably familiar with this question, right?
I am. And so, what that would be an example of is if two people have an order of custody that says, during the school year, this parent has this time and this parent has this time. And then in the summer months after school lets out until before school resumes, they're going to adhere to this schedule. So,
Okay.
I think that's the scenario that they're talking about.
Okay.
And with that, so if the two of you can't get along and you're falling back on your order, and when I say can't get along and falling back on the order, I mean the two of you have tried to talk about it, you can't figure it out between the two of you, you both have very different positions, and you just can't come to a mutual decision, then right now what you're doing is you're following the school schedule because while our kids aren't going to school, we're still in the school year, they're still doing academic instruction. However, that being said, if the two of you can get along and you want to follow the summer schedule, follow the summer schedule, because that's why we always add the language to your court order that says such other further different as you can agree. If you agree to something outside of your court order, then that's the best thing for your child, because two parents actually got along and reached an agreement on an issue affecting the child. And frankly, right now, the summer schedule would probably be helpful to the parent that is normally with the child during the school year, because let's face it, homeschooling's hard.
Oh
We
my
need to
God.
appreciate our teachers.
Yes, yes. I mean, like, it's insane because I'm like, oh, am I supposed to do what? And then work as well? And then I have to make you lunch? And then,
Right. Right. Breakfast and lunch and dinner and all in between. You have to get them on Zoom conferences and Google Classroom and get paper assignments done and reading assignments done and give them spelling tests and
right. So now
then getting
the other parent gets to help out a little bit, right?
right. I agree. I agree. So if you guys can work out a schedule where you have both parents doing the homeschooling, takes a little bit of the pressure off.
Yeah. That would be that would be really good. Like you said, like it will take some pressure off from the other one. Give him a little break. Okay, so I have one more question that came in from our audience, and it was okay. Okay, do I have to follow the court order? I'm assuming during COVID.
Absolutely. Absolutely. And if you have an attorney that's telling you you don't have to follow a court order, you should probably find a new lawyer.
Oh.
Court orders exist because the two of you couldn't quite do it without the court becoming involved. So once you get that court order in place and it's signed off on by a judge or a referee, it's an order and you have to follow it unless the two of you reach an agreement between the two of you that you're going to change or tweak or modify terms and you're both in agreement to it, then you have to follow the court order if there is no agreement. And there are consequences for not following a court order. You could be held in contempt of court. Civil contempt has a couple of things. You could be sentenced to a period of incarceration for up to 6 months. You could get placed on probation. You could get fined. You could have to pay sanctions. You could have to pay the other side's legal fees, not to mention what you're doing to your child during a period like this.
Right.
I mean, it's unprecedented. We have no experience with this whatsoever, and it's stressful on us as adults.
Right.
Imagine what it's doing to these kids who are used to being in school, used to being in activities, used to spending time with their friends. And if you take the other parent completely out of their lives while all of this is going on, you're going to damage your kid.
Yeah. That's a really good point. That's a really, really good point. So what about if they say, well, I didn't follow the court order because I believe that he or she was putting, the kid in danger or blah, blah, blah. Like if they have an excuse, will that be admissible in court once they go back through this?
I would say no, and here's why. Let me explain that. So if you believe right now that you have an emergency, that there's an emergency reason why you should not be following your court order, and the other side is putting the child in danger and you don't want to send the child, then the best option for you to do is to file an order to show cause with the court, explain to the court what you believe your emergency is and why your court order shouldn't be followed, and the court will decide if it's an emergency or not. If it's an emergency that warrants being heard, then they will do a conference with you and the Skype conference with the other side of the case, and they'll make a decision. They'll decide whether or not the child goes or not. Now, the exception to that would be a couple things. So, under Matilda's law, there's more to the shelter in place, which, by the way, is technically not a law, it's an executive order.
Okay.
Um, so there's a shelter in place that says that people that have compromised immune systems or are above a certain age or have certain risk factors, they should be quarantined to their own home, and absent an emergency, then um, they should not have other people coming into the home.
Mm-hmm.
When you read the executive order, it appears on its face to say if you have a child that has a compromised immune system, or if you have a child who is a high risk to potentially have fatal consequences if they were to contract COVID-19, it would seem under the executive order that you may have an argument as to why you didn't send your child.
Mm-hmm.
But you better make sure that you have all of your medical evidence and all your ducks in a row,
Mm-hmm.
meaning you better have taken the child to the doctor and discussed with the doctor, what's the risk if this child gets COVID, put it in writing, notify the other side what the doctor is saying, and document everything, because really the consequence could be that you could potentially lose custody going forward if you decide to ignore a court order.
Mm-hmm.
The
Okay.
other side of that is if you have a parent who has a compromised immune system, or the risk of COVID is too good for them and they fall under Matilda's law, then you have a potential argument as to why not to send the child for the parenting time with the parent, because as we know, as far as what's being said on TV is, and through the executive orders, is that, if Matilda's law comes into play and you're not abiding by it, there can be fines and consequences.
Mm-hmm. Mm-hmm.
So
Okay.
it's kind of a double-edged sword right now.
It is. It's insane. So, you have, let me see. We are gonna have to do this other thing, again, this advertising, so that you guys know this advice. And here we are again. Okay, so now Beth, so we just went over, you guys, the questions that the audience sent in. So now we're gonna go over some questions that Beth has received from her customers, like most of the ones that her clients ask her the most. So Beth, go ahead.
When can we file? When can we be heard by the court? That's the biggest two questions that I've been getting lately.
Okay.
And we don't have an answer. So we don't know when the court system will reopen for new filings. We have received guidance from the supervising judges and the
Mm-hmm.
administrative judges as to what's essential and what's not. And then they've created a new category of urgent.
Okay.
And urgent is at the discretion of whoever the on-call judge is when you file.
Mm.
So again, largely discretionary. What's urgent to one judge may not be urgent to another.
Mm-hmm.
And the reality of the situation is, unless it's an order of protection or a juvenile delinquency proceeding, or a situation where it's a removal hearing for child protective services, the court's not really inclined to hear it right now.
Mm-hmm.
They just reopened Skype communication with the court on our existing files, the things that have been pending in the court.
Mm-hmm.
And those Skype communications just started April 13th, where we started actually meeting with the judges and the attorneys via Skype, and sometimes the parties via Skype, to try to resolve the cases that we have out there to kind of reduce the backlog when we get back. Because the
Mm-hmm.
reality is, we don't know when we're going to be able to come back, and we don't know when we're going to start filing.
Right, right. So let me take it to the let me see. Do you guys on the internet have any questions for Beth? Let's see. Okay. So if you do, start typing it. And Beth, go ahead with the next question.
Another big question is, what do we do about medical? We have kids that need to be vaccinated. And what do we do about it? Where do we go, you know?
Okay, there you go. So I can hear you now.
Are you there?
Yeah, yep.
Okay, sorry, I lost you.
It's okay.
So what do we do about medical care for our children?
Mm-hmm.
We need vaccinations. We need to get our children vaccinated. Do we take them to the doctors? Do we not?
Mm-hmm.
Recently, one of the doctors who speaks for one of our local news station and gives updates and information sent out a message on Facebook that you should probably still be getting your children vaccinated. Again, in custody matters, it's the two of you should be speaking to each other,
Mm-hmm.
talking about it. What is each person's position? Do you guys agree that you should take the child in for vaccines? Do you guys agree that you should take the child in for the medical care that they need? Non-emergent, of course, because one would think that everybody could get along to say that if there's an emergency, absolutely the child would be seen.
Mm-hmm.
But like the basic stuff. And that's a big question lately. And if one parent or the other disagrees, what do you do? Because we don't have the remedy that we would have typically had to contact, draft a petition, get into court, and get a judge to render at least an immediate position on the issue that the two parents can agree on. And we don't have that ability right now.
Mm-hmm.
So I think long term, that's going to have some consequences too. Because, it's been pretty clear providers are putting out their doctors, like if you go to their websites, pediatricians, if you go to their websites, they're explaining what they're doing at their facilities to keep it clean and safe so that you can bring your children there to get their medical care.
Mm-hmm. I mean, that is tough because if they're saying, um, this is a huge topic, obviously a huge controversy about vaccinations and stuff like that. But, right now, if it's a vaccination, I believe it, in my opinion, it could wait. It shouldn't have to be a problem of like, oh, we need to get a court order to bring them to get a vaccination where a vaccine that maybe is required by school and then school is not even in session. I mean, I don't know. It's a huge, it's a huge controversy,
Mm-hmm.
for that. But
Mm-hmm. And
I
that's
mean,
one of the biggest controversies is the vaccination issue, both
mm-hmm.
because people, agree or disagree as to whether or not their kids should even be vaccinated at all, much
Mm-hmm.
less during a pandemic.
Right, right. I mean, like that's like I don't know, like let's just leave it there. So just because that's just like huge. All right, do you have one last question? The frequently asked questions before we say goodbye.
Will I get makeup time when this is all over?
Will you get make? Okay, would they get makeup time? Okay, all right.
Yeah, so especially with the people who aren't able to see their kids right now because the other side is playing, keeping the child from them because of their views on what should happen right now. One of the biggest questions that I get is, well, when this is all over and we can file in court, am I going to receive makeup time to spend time with my child to reestablish my bond and have the ability to work with my child and see my child and let them know that I love them and I care about them.
Mm-hmm.
And
Mm-hmm.
the hope is that when we're allowed to get back into court and we can have filings, that the judges will heed Judge Sunshine's advice and that there will be consequences for the people that withhold children from the other parent without reason to do so.
Mm-hmm.
And again, without reason to do so, I mean, obviously, if the other side has COVID-19,
Mm-hmm.
you're not going to send the child there, and you're not going to send the child there until they have, the negative screen
Right.
to show that they're clear.
Mm-hmm.
Obviously, you're not going to put your kid at risk that way, but absent something like that, they should be going back and forth.
Mm-hmm. Okay, so we have one question from the viewers, and here it is. If two parents temporarily modify a schedule due to COVID, does that set a future precedence in a custodial schedule?
I would say no. And I'm going to say that this is new territory.
Mm-hmm.
Typically, if two parents agree to modify a schedule and they operate under that orally agreed to modified schedule for a period of time, that is a serious factor that the court considers in permanently modifying the order,
Mm-hmm.
especially in our jurisdiction here in the Fourth Department, which is um, the local area, Onondaga, Oneida, Oswego. So typically, yes, that would impact your order if the other parent went to modify.
Mm-hmm.
But my guess is, and based on the article from Judge Sunshine, I know I keep quoting him a lot, but it was a very well written, very articulate article that explained how the court should view this situation. And
Mm-hmm.
it's available online. You can look it up. It was published on March 27th. Um, Essentially, I think that because this is so unprecedented and there's nothing for us to look at and say, okay, this is how we did it in the past, because frankly, we've never had a past where this exists.
Mm-hmm. Mm-hmm.
So I don't think that if the two of you put your child first and reach an agreement on how to help your child get through this with your help and the other side's help, and you guys are in full agreement on it, I don't see going forward how it would make it a permanent thing, unless, of course, we substantially change going forward permanently in some form, which doesn't seem like that's going to be the case as of right now, but who knows? Because
Mm-hmm.
we don't know what the new us is going to look like
Right.
going forward.
Yeah. Yeah. Very good, my love. Thank you, everybody, for watching and for your questions. If you have any other questions, go and contact your lawyer, right, Beth?
Yes, contact your attorney and listen to them. And if they're telling you things that don't quite feel right in your belly, find a different one.
You heard it from her, Beth Lockhart, family lawyer. All right, everybody, thank you so much for watching. You are watching Ana Hill at Officially Unofficial. Beth, thank you so much for being here with us and for answering our questions.
Thank you for having me. Have a
Okay.
great night.
Bye, everybody. Good night.